Well, good morning. We'll have a look at the further downfall and fall of Ken Kratz, but also to just before that, just to point out that that sort of video I did talking about Jerome, because she sent me that details of Mark Wiegert. Actually, there's an affidavit of Mark Wiegert saying that there was a blunt-blooded object in the back of the RAV, and yet we have no photograph of that blunt-blooded object. I mean, this is huge. I mean, that's most likely the murder weapon. So where is it? What happened to it? These photographs were taken of the car once it was open, the RAV4 once it was open. Where is this blunt-blooded object? This is this could be huge. We've thought all along that Teresa was killed with a gunshot wound to the head, 2 gunshot wounds. Why? Because Brendan tells us that there were all these gunshot wounds to her. And we found a magic bullet, a bullet that had Teresa's DNA on it, and wood, and a bit of paint. To me, I think this could be huge for Teresa, well, obviously for Teresa Holbach getting the truth. Stephen Brendan and Kathleen Zellner. We've got the lead investigator saying that there was a blunt-blooded object. Come on, Wisconsin, where the hell is it? This could really. Well, I mean, look, we've had our hopes built up in the past with the the issue of the bones being handed over. But the fact that there was a blunt-blooded instrument in the back of the RAV4, there's no photographic evidence of it. This is the first we've heard about it. Kathleen Zellner has always maintained, hasn't she, that that's probably what happened. Most likely scenario. She was attacked from behind. Maybe, I don't know, and she was getting her camera out, something like that. Wow. Anyway, let's carry on with our next part of the fall of Ken Kratz. Bizarrely, some lawyers, Dean and Jerry, for example, just after Making a Murderer came out, and even to this day, they have a certain amount of sympathy for Ken Kratz. I don't get it. I'm not going to get the violin out and start playing for Ken Kratz. He had come into him what he had come into him. And the fact that since Making a Murderer has come out, he's still trying to defend his ridiculous conviction of Stephen Brendan. No, I have no sympathy for Ken Kratz at all. However, we now get to the nitty-gritty. Item 49. We turn next to the issue of costs. The Office of Law Regulation filed its settlement of costs on August 12, 2012, listing $23,904.10 in costs. Supreme Court rule required Attorney Kratz to file any objection to the OLR's statement of costs within 21 days after service on or about September the 10th, 2012. On November the 14th, 2 months later, over 2 months past the deadline, attorney filed an objection to the statement of costs, along with a motion asking the court to accept his late filing. Attorney Kratz offered no explanation for the lateness of his filing. We reject Kratz's unexcused late filing. Our deadlines are not mere suggestions. Filing documents with this court over 2 months late with no semblance of a reasonable excuse has its consequences, as the Seventh Circuit has explained. We live in a world of deadlines. If we're late for the start of the game or the movie, or late for the departure of the plane or the train, things go forward without us. The practice of law is no exception. A good judge sets deadlines, and the judge has a right to assume that deadlines will be honored. Even if we were to consider Attorney Kratz's objection to costs on its merit, it falls well short of convincing us to impose anything other than full costs. If anything, Attorney Kratz's untimely objection to costs hurts more than it helps his cause. In his untimely objection, Kratz insists that he should pay no costs whatsoever. The OLR asks us to impose full costs consistent with our standard practice under 2224. The court's general policy is that upon a finding of misconduct, it is appropriate to impose all costs, including the expenses of counsel for the Office of Lawyer Regulation, upon the respondent. In cases involving extraordinary circumstances, the court may, in the exercise of its discretion, reduce the amount of costs imposed upon a respondent. In exercising its discretion regarding the assessment of costs, the court will consider, oh dear, the court will consider the submissions of the parties and all of the following factors: the number of counts charged, contested, and proven, the nature, the nature of the misconduct, the level of discipline sought by the parties and recommended by the referee, the respondent's cooperation with the disciplinary process, prior discipline, if any, other relevant circumstances. The referee has recommended an equal split of the costs. In his report, the referee stated that although the court's general policy is to impose all costs against a respondent upon a finding of misconduct, one of the relevant factors set forth in 2224 warrants deviation from the standard rule. Oh, well, we're used to deviation from rules in Wisconsin, aren't we? That factor, according to the referee, is 2224(1)(m), the number of counts charged, contested, and proven. The referee noted that the OLR spent more than the usual time and effort in locating and arranging for the testimony of the two grievants, JW and MR, whose claims form the basis for 4 misconduct counts that the OLR dismissed at or shortly before the start of the scheduled disciplinary hearing. The referee explained that although it is not at all unusual for the OLR to dismiss claims during the course of a disciplinary proceeding, it would seem unfair to impose all the costs on the respondent. No such luck, Kratz. We disagree with both the referee and Kratz and impose full costs. Under SR 2224, the court has the exclusive authority to decide the appropriate assessment of costs against a disciplined lawyer. We note that at the time the referee filed his report recommending halving the costs, normally assessable against Attorney Kratz, the referee was operating at an informational disadvantage. Consistent with SCR, the OLR filed its statements of costs and an itemization of costs several weeks after the referee filed his report. Reviewing the costs issued de novo, we disagree with the referee's recommendation that the costs assessed against Attorney Kratz should be essentially proportional to the percentage of counts on which the OLR prevailed. It is true, as the referee emphasized, that the law states as a factor to consider in reducing costs the number of counts charged, contested, and proven. Our rules, however, require that to impose less than full costs on the lawyer disciplined, the court must find extraordinary circumstances. Only if and when the court finds that extraordinary circumstances exist in a particular case may the court consult the factors listed in 2224 through to F to guide the court's imposition of costs. We do not find extraordinary circumstances present here. To begin with, it is not extraordinary for the OLR to prosecute all misconduct counts for which the preliminary review committee found cause to proceed. And in the words of the referee, it is not at all unusual for the OLR to dismiss claims during the course of a disciplinary proceeding, as was the case with the 5 misconduct counts dismissed here. As for who should pay the cost of litigating dismissed misconduct charges, the disciplined lawyer or the other attorneys in this state, this court has chosen the former. So as for who should pay the costs of litigating dismissed misconduct charges, the disciplined lawyer or other attorneys in this state. So, yeah. The court has chosen the former, barring extraordinary circumstances. Exactly. Why should other attorneys that don't engage in the sort of misconduct that Kratz does have to pay, which by definition we do not normally find? Or see also 1998, rejecting objections to full assessment of costs based on an apportionment of the number of misconduct allegations established. Disciplinary, let's see, we're at the end of that one, so we go back up here. There we go. We note that as an appellate court, we know only what the record contains, and we do not know precisely why the OLR dismissed the counts that it did. Nor should we. This court's function is not to armchair quarterback the OLR's litigation decisions, but to review the record and determine whether the referee properly concluded that the respondent violated the ethics code by engaging in misconduct. I just wonder, was there a little bit of a tit for tat deal? We'll drop 5 of the charges, but you have to plead no contest, which ultimately helps Kratz anyway, doesn't it? Because if it had gone to like a full trial, then, and it was found against him, he would have far, far more costs to pay. Anyway. Number 50. We also find nothing extraordinary about attorney Kratz. No, Kratz's claim. He's certainly not extraordinary. He's certainly not the prize. Stridently advanced in his untimely objection to costs that he was willing to conditionally admit some of the misconduct charges several months before the scheduled disciplinary hearing. We reject the premise of attorney Kratz's argument that he has been dragged through an expensive disciplinary process while furiously waving the white flag of surrender from the very beginning. This simply is not true. Let's read that again. That's brilliant. We reject the premise of attorney Kratz's argument that he has been dragged through an expensive disciplinary process while furiously waving the white flag of surrender from the very beginning. This simply is not true. This is going to be good. The primary basis for attorney Kratz's claim that these disciplinary proceedings were unnecessary is a single email dated about 2 weeks after the OLR filed its complaint from attorney Kratz to the OLR's counsel. In this email, attorney Kratz stated his willingness to enter no contest pleas to some, but not all, of the counts to which he ultimately pled no contest. He offered to enter no contest pleas to the 3 counts involving SVG, to which he ultimately pled no contest. He denied misconduct towards RH. He stated he had no recollection of making the vulgar remarks to SS and would prefer not to admit to something I do not recall. And he denied that any one-time crude remarks could constitute harassment. He stated that this count, presumably the offensive personality count concerning SA, could result in a no contest plea if you want a second incident to hang your hat on other than SGV. He stated that although he would accept a 6-month suspension, he wanted the suspension to take effect less than 3 weeks later and to be given credit against his suspension for an over 5-month period during which he had removed himself from the practice of law. We note that with his request for an over 5-month credit against his proposed 6-month suspension, attorney Kratz was proposing that he receive a net suspension of about 3 weeks. Attorney Kratz explained that he intended to move out of state and his opportunity to be licensed elsewhere requires my reinstatement here. In its reply to attorney Kratz's untimely objection to cost, the OLR informs us that it chose not to accept the terms stated in attorney Kratz's email. The OLR states that it did not agree with attorney Kratz's suggestion that the time he allegedly refrained from practicing law should be credited against any imposed suspension. The OLR also did not agree to starting the suspension period less than 3 weeks after the date of the email. The OLR further informs us that it reminded Attorney Kratz from this court that this court prohibits parties in OLR cases from engaging in plea bargaining. Wow. Finally, the OLR tells us that at the time of Kratz's email, the OLR director reconsidered the viability of each misconduct count and determined it would be inappropriate to drop the counts suggested by Attorney Kratz. We decline to equate Attorney Kratz's highly optimistic settlement offer with an extraordinary circumstance sufficient to justify a reduction in costs. Although we have long allowed lawyers and the OLR to enter into stipulations of fact and law and jointly request the imposition of a justifiable level of discipline, we refuse Attorney Kratz's invitation to undertake the task of evaluating the parties' efforts to reach such a stipulation, i.e. to review the history of the parties' case discussions in order to determine who was willing to stipulate to what, when, and at what consequence. Whether a stipulated outcome was reasonably achievable and how much the costs totaled at the relevant points in time. 61. This is not to say that it is impossible for an attorney to limit or even eliminate the imposition of costs under Statute 2224. An attorney may entirely avoid paying the costs of a proceeding by entering into a comprehensive court-approved stipulation prior to the appointment of a referee. This was not done here. After the appointment of a referee, an attorney may stop the running of costs by entering into a stipulation that eliminates the need for further litigation. This was not done here. What was done here, according to the record, is that Attorney Kratz emailed a stipulation proposal form in self-interested terms, and the OLR rejected it. This is not an exceptional circumstance. To modify a familiar refrain, you can't always get what you want or what you need. We do not find the costs incurred extraordinary either. The costs consist of about $15,000 in fees and disbursements from the OLR's counsel and $5,700 in referees' fees and mileage expenses, and about $2,900 in court reporting and other costs. Attorney Kratz does not argue that these costs were in any way inflated. He does not challenge the billable rates of the OLR's counsel or the referee, or the time spent by either on any particular task. He does not challenge any disbursements or expenses as excessively high. He does not do what 2224 instructs. Explain, now I like this, with specificity. Yeah, you like that word, don't you, Kratz? Yeah, explain with specificity the reasons for the objection to costs and state what he considers to be a reasonable amount of costs. In place of specificity, there's that word again, Kratz resorts to hyperbole. He writes in his tardy objection to cost. They are really going for him now. That's great stuff, isn't it? As this court should by now have undeniably determined, there is nothing ordinary about this disciplinary case brought by the OLR against the respondent and the assessment of any cost against the respondent as a result of the OLR's insistence on a formal hearing is unjust and borders on the intellectually insulting. It was the respondent himself who has done everything since well before any formal grievance was filed with the OLR to resolve this entire matter with professional humility, having immediately and consistently taken full responsibility for any possible Supreme Court violation. Oh, it's been there. That is definitely Kratz's writing, isn't it? Yeah. Yes, he writes in his tardy objection to costs. This is Kratz. This is typical, isn't it? As this court should by now have undeniably determined there is nothing ordinary about this disciplinary case brought by the OLR against me and the assessment of any costs against me. As a result, the OLR's insistence on a formal hearing is unjust and borders on the intellectually insulting. Well, you know, you're going to really get their backs up there, Kratz. It was Ken himself who has done everything since well before any formal grievance was filed by the OLR to resolve this entire matter with professional humility, having immediately and consistently taken full responsibility for any possible Supreme Court rule violation. The record proves otherwise, Ken. In every stage of these proceedings, Ken Rapist Kratz has employed a tooth and nail litigation approach. He denied all misconduct in his answer to the OLR's complaint and raised various constitutional, jurisdictional, and procedural defenses. He accused the OLR of operating under a conflict of interest and of unethically leaking information. I think we know where that comes from. That's to do with the fact that he's asking Ryan Foley, you know, where did you get that? Where did you get, did you get the OLR letter from the OLR? He moved to dismiss the OLR's complaint on 9 separate grounds. The referee later rejected the motion as replete with bare assertions of fact, which were not properly before the referee and may not be considered. He engaged in rigorous discovery practice, including propounding over 125 interrogatories, filing discovery motions, and attempting to compel the production of documents from third parties. He raised arguments that ranged from the incredible, e.g. disputing his text messages to Stephanie contained sexual overtones, to the hyper-technical, claiming the OLR complaint was barred by the civil doctrines of issue and claim preclusion because an OLR investigator initially declined to forward Stephanie's grievance for formal investigation. To the inconsistent, denying any recollection of making inappropriate comments to SS, but claiming credit for having recognized their inappropriateness and apologized. Yeah, that's a bit pretty inconsistent, isn't it? Yeah. Denied doing them and then apologized, to the puzzling, arguing that he could not have told RH reporter that reporter had big, beautiful breasts because the reporter in question was beautiful, but not large-breasted. It was, of course, Kratz's right to vigorously contest the misconduct charges. But 2224 makes clear that when a lawyer whom this court ultimately finds guilty of misconduct imposes costs on the disciplinary system, he or she must expect to pay. And litigation, as every litigant knows, is not cheap. We refuse to transfer the litigation costs that Attorney Kratz has generated to the other attorneys of the state who are innocent of any wrongdoing. In the end, there is nothing extraordinary here from a costs perspective. Our general rule is to impose full costs upon a finding of misconduct, and we do so here. We're at number 67. I think we're 2/3 of the way through, maybe slightly more than that. I think there's, no, actually there might be just over 100 those little paragraphs, but yeah, that's it's very pleasing to read that and to realize that every now and again the system does get it right, and they do take into account everything that Ken Kratz was doing, and they see through his charade. Anyway, catch you all soon. Off to the Speedway tonight, hoping for a Bandits victory, but just to see nearly the full team in action would be nice. We've got 2 riders back from injury. So anyway, I'll no doubt do a couple of short live videos from Redcar once I get there. Catch you all soon. Bye for now.